So today we're talking about applications for entry of default. I guess this will be my follow-up to my video on how to write entry for default. I'm going to talk about many lay people's misunderstanding about this whole thing, and then specifically Chili's use of this entry of default, and then I think also some supposed alleged attorneys like Murby's is also on the same boat. I hear he made a video, but I hope Kate's attorney, no, I hope he isn't smart enough to actually see Chili's strategy here. All right, so we're gonna be watching part of Kate's video where she covers Chili's entry for default.
So this was entered on his amazing, very serious, very professional lawsuit that he has here. So for anyone who isn't aware,
yeah, lawsuits are pretty serious, Kate. You should probably start taking it. So
my answer was due today, but last week I realized that I probably wasn't going to be able to secure an attorney in time to really, either file a motion to dismiss or a good answer to this. So I wrote.
Really, last week, this whole time, I mean, either you've been doing nothing, which I don't think is the case, or B, you've been talking to attorneys who won't represent you because they're not stupid and see that you clearly have no case for defense here.
Wrote into the courts and I said, hey, listen, I'm a defendant on this case. I'm trying to find counsel. It's appearing like I might not do it. Could you please extend the time that I have to answer? And the judge immediately gave me 30 days.
Yeah, and in interest of finding on the merits of a case, judges will often do that, even though you completely broke the rules of the court. Like you're talking about Chili breaking the rules of the court by talking to you directly. Like, what rule is that, Kate? Stop making crap up. But yeah. So when you file a motion, you're supposed to confer with the other party, and you never did that. You also basically, I mean, you didn't. Well, maybe you did wait till the last minute and did this on purpose. This was your strategy. But it's obvious that the judge hears his motions on Monday. So because the following Monday would have been past your deadline to reply, basically, even though he didn't write it up that way, he didn't just interpret your letter as a motion for extension of time, but for an ex parte motion for extension of time, which you had no legal right to. You definitely did not even specify a reason. If we go back and look at your letter, which I don't have it ready here, you just say, I've been trying to find an attorney. I need an extension of time. You didn't say, I have been unable to find an attorney, or that I've been trying. Well, I don't think you tried. So, and in Chili's motion, you don't have the right. You guys keep saying, what is this, Nazi Germany or whatever? Everyone has the right to an attorney. I mean, you guys are completely, because you are idiots. You don't have the right to attorney in civil court. That's not a right. You have a right to counsel in a criminal complaint. Because they're so friggin' dumb. It just hurts my head. I've been wanting to report on this, but I wanted to wait until after these entry of defaults have been terminated.
It's a reasonable request, right? So in the interim, as of today, actually, the funds have gone over to the attorney, and I have retained counsel. I have an attorney. He should be entering an appearance. If not tomorrow, then early next week.
Which didn't happen. I think he I don't know. I haven't pulled up the PACER report, but I hear he just did it yesterday.
Should see that come up. I'm very happy with the attorney that I picked. I'm not going to get too much into it, but I'm very happy with it. It's a legitimate First Amendment.
And she thinks she needs a First Amendment attorney here again, which I don't know. I guess that's probably what you've been telling the attorneys when you're looking for them. Look, I'm just exercising my First Amendment, and this guy just keeps filing lawsuits against me. You, you well went way past the First Amendment. And I look forward to your attorney actually watching the videos and seeing the obvious defamation statements based on supposed facts.
Attorney, which is what I needed. So as of, I think it was the 3rd, it was October 3rd, the courts had allowed me this extension. Here it is now, the 6th, and Chile is applying for an entry of a default judgment against me, despite the fact that I have not defaulted because the time that I have to answer this has not expired yet.
Yeah, again, this is dumb, and I don't want to say a lot, but your actual time to reply ends tomorrow, 10:14, and you're not smart enough to know that. Murbeast isn't smart enough to know that.
He doesn't want you to have a fair legal process at all.
No. I think originally so he's changed it from what he first read out in his stream the other day. But he read out, he called what did he say, that I'm not entitled to representation for my frivolous defense. I mean, that's just
he read out frivolous lawsuit, didn't he?
Oh no, your defense can never be frivolous. That is some dystopian storm.
Your defense can never be frivolous? That's hilarious. Yeah, that's why people win lawsuits, because people's defense is always on the merits.
Trooper, Darth Vader type shit, like resistance is futile, thinking that somebody defending themselves could ever be construed as frivolous. That's insane. But this is what he's done.
You're insane.
And he goes on and he says, note the filing motions for an extension of time to answer the complaint was not found to be considered an appearance that required notice before application for default in Benny v. Pipes 799F.
And this is funny because she doesn't even read the words. Like, what she ends up doing is just going and Googling. Like, just read the words. Like, they're pretty clear here.
F2D 489493, 9th Circuit, 1986. So when you look at this case, again, Chile has just completely misunderstood and misconstrued the law because he is a literal fucking idiot.
Or the opposite way around. Kate, you should really, I don't know, stay in your lane.
The facts of the case here were that the defendants were served with a lawsuit. They asked for an extension. They were granted the extension, and they still didn't answer it anyway. So, I mean, essentially, Chile, in order for me to default, the time allowed to me by the courts, because they're in charge, not you, would have to expire without me giving an answer before you could get a default judgment. But okay, all right, yeah. This is Chile's amazing understanding of the law. So,
yeah, this is Kate's amazing misunderstanding of the law. Like, that's the way that case law works, right? Like, the facts have to exactly match the facts. So, in the whole Roe v. Wade, right? You only have the right to a pregnancy, an abortion in the first term if the name of the doctor is Wade. No one else has the right to do that. That's just totally dumb. So I'm going to break down this in more detail in just a minute.
I'm glad that we have that there, right? So that was good. All right, okay, we have almost 1,200 people in here now. Now is a good time to start, I think. So I'm going to show you these documents, and hold on. All right, I'm going to show you these documents. I am not going to.
So I don't think the rest of the video is necessary. What we're going to do is we're going to look at the comments, from some of the comments from this video also. So Anne, not a very lovely person who comments incessantly and apparently has nothing better to do than to Google the stuff and then think she's an expert. What is that? The Dunning-Kruger? So she says, I read the Benny v. Pipes case, and in that case, the defendant obtained 2 extensions and then never responded, which certainly isn't the case here. Once again, Chile is showing he doesn't comprehend what he's reading. Again, it doesn't matter. So, in fact, you kind of point out what he was saying. So the defendant obtained 2 extensions. That sounds familiar. I think that was what was alleged in the video. That note that filing motion for an extension of time. That seems completely relevant. So, so Anne, stay in your lane. I am a scholar of poop, maybe. Says, Toledo simply Googles things like court case plus extension and then references the first link that comes up without even reading it. Yeah. All right, poop scholar. Totally nailed it. Shannon Swanson says, I read through the court cases in his defamation lawsuit, and they're all the same way. I don't even remember if he mentioned court cases in it because it really doesn't matter. I mean, that's really not the place to do that is in the complaint. It's all about facts and elements and relief. That's all. And you're too dumb to know that. So he picks sentences out of the case and thinks it applies. Most of the cases just allow people to continue with the suit, and one of them actually supports the opposite of what he's claiming. I don't know. So apparently Shannon is doing her Google legal analysis of the original complaint. So Thomas Becker says Benny v. Pipes was a completely different thing. Prison guard were handed paper documents, crumpled them up, and then threw them away. Yeah, because Kate didn't do that, right? She didn't tear up documents and throw them away. Oh, she did, by the way, for those who think I'm not being sarcastic. And Ann Balgard says, they also received several extensions. And again, it's not relevant, right? All the facts don't have to match. It's not how case law works. So Ann says, they also received several extensions so they could file the responses, but never filed anything. Ignored it completely, and then the court granted the judgment. That's kind of where we're at right now, right? So Kate filed an extension and has not filed a response. Ever has she filed a response. And then Ba'a, must be a sheep. Oh, that makes completely sense. He's a sheep. Says absolutely, and after filing 3 requests for extension for 10, those defendants never responded to the complaint. Reason why an order of default was entered. Chili's diluted motion was filed prematurely on the last day Kate had to answer. You guys need to do your math right. And actually, if you guys don't even want to read on how to calculate time in the legal system, there are many calculators online. Just Google it. And also disregard the court's order granting Kate 30 additional days to respond. So, as far as I know, Chili had not yet received even a copy of Kate's. Oh, wait. Actually, we're going to get into that in a minute. He did receive her letter. He had not received an order on that letter yet. So the whole reason, all right, so let's go back to Benny v. Pipes, all right? Note that filing motions for an extension of time to answer the complaint, right? So he had received Kate's letter, was not found to be considered an appearance that required notice before application for default. So what Chili here is saying, and it's plain English. I don't know why you stupid people, oh, sorry, because you're stupid. That makes sense. To understand it, is Chili had received the letter. Normally, if the other party had appeared, you would need to give notice before you did application of default. But Chili realized that there was a loophole there, or whoever's his attorney is. I'm guessing he has an attorney right now, helping him at least. So he was like, well, I don't want to have to send notice before I file my entry for default, because that's going to delay things. Oh, there's this loophole. So as it turns out, Kate didn't file an appearance by just filing a motion for an extension. So he can file his application for entry of default without doing notice first. So that's the case that decides that, Benny v. Pipes. And I've seen some people also say that it's a different circuit. Learn how to interpret that. So, let's go into that. So, there's this document, that kind of breaks down this, that I recommend you all Google and download. It's by the Georgetown University Law Center. It says, which court is binding versus persuasive cases? Let's go down to the bottom. All right, so federal issue and federal district. Let's look at the headings. So, state or federal issue, which court are you in? Binding authority and the persuasive authority. All right, so we're a federal issue in federal circuit court. Yep, that's where we're at. And then, actually, yeah, it's a federal issue. It's because a lot of his other things, right, and his lawsuit are going to be state issues. So look, persuasive authority, all federal courts, other state courts, interpretation from the state's highest court. So don't be surprised if Chile starts citing cases from California. And you guys are going to be like, oh, that's so dumb. But it's binding authority. So here we are. So federal issue in federal district court. Binding authority is be a citation to a Supreme Court decision or a federal circuit court in the circuit where the district court is, right? So he cited a Ninth Circuit court case. Why is that? Probably because that hasn't been ruled on in a First Circuit court yet. It eventually will be. Maybe if Chile's court case goes all the way to appeals, then it'll, or to the Supreme Court, then we'll be good, right? And then what people will do is, in the First Circuit, they'll cite Chile's case, and then when you read Chile's case, it'll say it originally cites the Ninth Circuit case. So it's kind of just like a big old loop. Until that happens, it's persuasive authority, and Chile's not responsible to specify that. Because you know what? The judge understands how that works. So, other federal circuit courts are persuasive. Federal district courts are persuasive, and all state courts. So, who is dumb? It's all of you friggin' idiots who should really stay in your lane. And it sounds like Murby needs to start doing that as well. If you're relying on any of these law experts that are in the troll farm, okay, you are in for a world of pain. So, I think that's all I had. Again, your last day for reply is today. So it doesn't look like it's going to happen. So let's see how the judge rules.